Hello, everybody. My name is Joey Barnett. I am a partner at WR Immigration. I specialize in EB-5, and you are listening to our EB-5 Investor Outlook, January 30, 2024, chatting with Charlie. I, of course, am joined with Mr. Charlie Oppenheim, who used to work for the Department of State in the Visa office, writing the Visa Bulletin that is published every month. Charlie, it's great to see you.
It's wonderful to be on the call.
So EB-5 is booming right now. There is a lot of activity. A lot of folks are looking into it for the first time. And the point of this presentation today is to give a good outlook for them, what they can see in the future as they are planning their immigration journey. And there is nobody better to help us guide through the immigration delays and processing than Charlie. So it is great to have him here to give us his insights. This is, as we always say, there I am, and there's Charlie. Great to see you guys. We've been doing this for just about a year now. It's always been a Zoom call that's been recorded, but we are moving into the next phase of digital marketing, and we are going to be going onto LinkedIn Live and streaming live on YouTube in future months. So you'll still be able to register the same way. It'll just be a different platform that you'll be looking at us in, and hopefully that will generate some more views as well. This is not legal advice. It's for informational purposes only. But if you have questions about your EB-5 case, or you want to set up a time to do a consultation to discuss EB-5 and any questions that you have, please reach out to us at visalaw@wolfstorff.com, or you can check out our website, www.wolfstorff.com, and you can complete a questionnaire and we'll schedule a call. So EB-5, and of course, Journey Forward with WR Immigration. Our firm is one of the top immigration firms in the United States. We have over 9 offices. We are considered one of the top firms in EB-5. Our managing partner, Bernie Wohlstorff, was just acknowledged again as one of the top EB-5 attorneys. And my partner Vivian and I also were named as top 25 EB-5 attorneys by our peers. I'm on the ALA EB-5 committee, and so is Bernie, and so we are very much on the cutting edge. We have filed over 5,000 EB-5 cases and have helped thousands of people get their green cards through EB-5. So you're talking to the right people, you're listening to the right people, and we are here to help, and we want to help. So we're going to be talking generally. Here's our roadmap for today. We're going to be talking about some of the data that USCIS released. We're going to be talking about the Visa Bulletin and why the EB-5 window of opportunity is now. And we're going to be talking about potential fee increases by USCIS. That was something that was just recently announced. And then we're going to be talking about the reserved EB-5 categories, which were created by the EB-5 Reform Act. That's where a lot of the new investors are going, because you can qualify for the lower minimum investment amount of $800,000. And for Indian and Chinese nationals, you're able to get into these new visa lines and potentially skip the backlog that is existing for pre-RIA investors, those who filed before March of 2022. So let's just jump right into it. And of course, if you have questions, we have our question and answer feature. Feel free to put in the chat. Feel free to ask a question, and we will do our best to answer them as soon as we can, or as part of the at the end of the time. So let's get into the processing data. Every quarter, USCIS puts out processing data, and what they indicated was that in fiscal year 2023, they processed 3,316 I-526s, including 63 I-526Es. The I-526E is the petition that a regional center investor files now. And interestingly, they show that every single one of those 63 that they processed were approved. This is excellent to see. It means that folks are working with competent immigration attorneys to get their source of fund documentation in order. One of the big differences with EB-5 post RIA is that they're going to approve the project first through this project-based application, and then the I-526E really only relates to the investor's source of funds. And so the I-526E is the petition that the immigrant investor files, and they work with immigration attorneys to document, compile, and organize information explaining to the U.S. government how that money was lawfully earned and transferred into the EB-5 project. Interestingly, though, they had approval rates for pre-RIA investors was actually pretty low, but it is a little bit deceiving because that the denial rate that they include there also includes withdrawals. And there have been a fair number of people who are withdrawing their I-526 from consideration by USCIS. In particular, many Chinese nationals who filed in 2017, 18. They're looking at these backlogs. And they're saying, you know what, my children may age out based on the limited supply of visas, or hey, I can jump into a new reserve visa category. So I'm withdrawing my old application and filing a new one with an additional $300,000 and filing a new case. So that case approval rate for the legacy I-526 cases, I look at it with a little bit of grain of salt, but I also have some just practical experience of they are issuing requests for evidence on these I-526s, and they are digging into source of funds very, very deeply. And, you know, they're kind of throwing the kitchen sink at folks with requests for evidences on that. So that's what we're seeing. It's great to see that they're finally approving I-526Es. I'm also really pleased to announce that, I think it was last week, I heard that USCIS approved an adjustment of status for an EB-5 investor that had an approved I-526E, which means that investor got the first reserved visa number from fiscal year 2024. It's excellent to see that those visa numbers are starting to get used, and we want to see a lot more of that, and we're going to get into that in just a moment. So this here is Chart A from the Visa Bulletin of February 2024, and it lists out the EB-5 categories. There's 4 EB-5 categories. The 3 new reserved ones, rural, high unemployment, and infrastructure, those all remain current. And then there's the unreserved visa category, which is pre-RIA investors and those who file at the 1,050,000 level because you're not located in a rural high unemployment or infrastructure project. So Charlie, can you first, I got a series of questions here for you. First is, did we see any movement in the unreserved category from January to February?
The China unreserved date advanced 1 week, and the India date remained steady at 1 December 2020. So minimal movement at this point. I would expect that there should be some movement in these categories for both China and India unreserved in the coming months. The reason for that is they get their normal fiscal 2024 unreserved limit based on the overall employment limit, plus they get the benefit of the unused reserve numbers from fiscal 2022 that were not used and can be added to this, making it an extremely high annual limit for unreserved. And it would be extremely beneficial if the maximum amount of these numbers can be utilized during fiscal 2024 under this high limit. That would be a big benefit for both the China backlog and the India backlog.
Thank you. And for these new set aside visa categories, they've always been current since their existence. Can you explain why and what you expect to see in the next few months and maybe even through the end of 2024?
Sure. A final action date should only be applied once the State Department has determined that the demand and actual number use of the numbers will exceed the annual limit for the fiscal year. As you just mentioned, only one has been reported issued so far versus the 2024 annual limit. So there is no reason to apply a final action date. And I believe that all three of the reserved categories will stay current throughout fiscal 2024 because there is not going to be enough demand to use with approved petitions to utilize all available numbers. And I think that the current status will remain in effect well into fiscal 2025.
And so that is the opportunity that a lot of folks, especially those in the United States, are able to take advantage of, is that it's current today, which means you can file your adjustment of status at the same time that you submit your EB-5 application. And this is an incredible opportunity for folks in the United States, in particular for those Indian and Chinese nationals on H-1Bs who are stuck in EB-2 and EB-3 visa backlogs and have children that could possibly age out. EB-5 is an opportunity for them to get in a separate, mutually exclusive green card line and get the green card through EB-5 at a faster pace than if they were just staying in the EB-2 and EB-3. Now, we don't have the full Visa Bulletin for employment based up here. And we do have a separate Chatting with Charlie where we focus specifically on the more standard EB-1, 2, 3 employment-based categories. And if you really want to get in depth and learn, I highly advise you listen to Charlie and my partner Sharina and our great associate Laura talk about this. But Charlie, maybe you can give us just like a 30-second or a minute sort of breakdown of why we're seeing such slow movement for EB-2 and EB-3, and let's just say for India, recently.
Sure. The Immigration Nationality Act allows for, if there are going to be otherwise unused numbers under the annual limit for, in this case, the employment second preference or third preference annual limit, then those numbers can be provided to countries which have already reached their per country limit. And those numbers are provided strictly in priority date order. Therefore, Indian applicants typically have the earliest second and third preference priority dates, and they receive the vast, if not total, amount of those numbers. So in past years, both India's second and third that have benefited, allowing those dates to advance at a faster pace. That is not going to happen in fiscal 2024, potentially going forward, because as long as there is a rest of world final action date listed, that means both China and India will be subject strictly to their per country limits. And that is going to result in extremely slow forward movement of the India and China employment second and third preference final action dates.
Thank you. And I just want to sort of reiterate what Charlie just said, is that we can't expect the same forward movement as we had in previous years, that we kind of had artificially inflated worldwide limits because of COVID-19 and the shutdown of consulates worldwide and the resulting carryover is not the right word, but the transfer of unused family-based visa numbers to the employment-based visa numbers. That isn't happening as much, and we're starting to see the annual limits come back to what they normally are. Is that correct, Charlie?
That's correct. And in fact, in fiscal 2025 and going forward, India and China, second and third, potentially could get 5 to 10% fewer numbers than they are getting this fiscal year. So The wait times are going to increase. The beauty of the reserved categories is that if an applicant has the means to do so, they could file a fifth preference reserve petition and still have their employment for second or third pending, and whichever priority date is reached first, they get a visa in that category. So you have basically two chances at a visa number each and every month.
One question that I'm commonly asked is, can you port your EB-1, 2, or 3 priority date to EB-5? The answer to that question is no, you cannot, unfortunately. So your priority date for your EB-5 is based on when you file your I-526. The I-526 requires an at-risk investment. And so you work with your immigration attorney, you prepare your source of funds report, then you transfer the investment capital to the EB-5 project, then you file your I-526 and get your priority date. And so there is sort of a series of steps that need to be taken before you establish your priority date. And the longer you take to do that, the more likely there's going to be somebody else who's filing before you, and your spot in the line is going further back, and there could be longer visa backlogs. Because Charlie, you mentioned the Visa Bulletin today is current, but that doesn't really matter so much as when you can get your adjustment of status approved. What matters? What matters when your I-526 is approved, right?
Correct. The dates we're seeing here reflect what's for February. The Visa Bulletin is always talking about the upcoming month, the current or upcoming month. It does not guarantee visa availability in the future. And when your case is ready for final action, whatever date is applicable at that time determines whether it can be finalized or not. But it's always extremely important to get your petition filed in any category you're filing under, so that you're as close to any line, close to the front of any line, which may develop at some point in the future.
So let's look at Chart B. Date for filing. I believe USCIS is still accepting Chart B for adjustment of status. Generally, that usually happens in the beginning of the fiscal year when there's more visas available, and starts to change. They'll go back to Chart A at some point, right, Charlie? Isn't that normally how it works?
Yeah, as soon as the Immigration Service determines that enough petitions have been filed to reach the annual limit, they will revert to only allowing Chart A to be used. And that typically happens somewhere in the January to March timeframe. So it's extremely important, if a person has the ability to file under either the China or India date at this time, that they do so during February, because there's no guarantee these dates will be allowed to be used in the unreserved categories for the month of March and future.
So I'm thinking
one other important thing to mention is these dates reflect where the State Department, in conjunction with, or in consultation with USCIS, believes the final action dates will be within 8 to 12 months.
Right. So that's a great point. So what this is saying is that in 8 to 12 months, the final action date for China, which is December 15, 2015, may start moving closer and closer to this January 1st, 2017 date.
Right.
And for the India pre-RIA investors, if you're in the United States, you should file your adjustment of status now. There's nothing that should be stopping you. For new investors, it doesn't really matter whether USCIS accepts Chart A or Chart B at this time, because they're both current. That's the opportunity that you have. So, all right, thank you, Charlie. One of the things that is news this week, or maybe it was the end of last week, is were some proposed fee increases from USCIS, and the White House just approved that. And so what we're waiting for is a notice in the Federal Register saying, hey, these new fees are going to go into effect. In the past, they will usually say, hey, they're going to go into effect in 60 days. So we're waiting for that register notice to come in. And for folks who are looking to do EB-5, this could be a consideration to file in the next month or two. You can save a lot of money by submitting your I-526E in the next month or two. Similarly, if you have an I-829 window, you should be and you're in it, you should be filing it now, not in 2 months, potentially when you still are allowed to, but you're going to be paying an extra potential $6,000. So we're waiting to see that. And then I also wanted to put down at the bottom here the 956 filing fee. They have increased that significantly up to almost $50,000 for a regional center designation. And, whether this is fair or not, I'm not going to comment on. I just know that USCIS does a lot of processing of humanitarian-based cases, and they don't always get the best fees to do it. There's a lot of work. And so they use fees from EB-5 investors to kind of supplement their workload for all of the humanitarian work that they do. I think there is some worthiness there, but it is something that is very interesting to see. I think USCIS gets 96% of its funding from filing fees, not from congressional appropriations. So these fees are really what keep USCIS processing. And what USCIS has said is we need to increase it in order to make sure that there aren't further backlogs and processing delays. Charlie, anything you wanted to add here?
In the past, when these type of fees have gone into effect, the service has also indicated these are going to expedite processing of cases, so reducing processing times because they can use these increases to hire additional staff, etc. So whether that will happen or not, it remains to be seen.
So I want to take a step back, in particular for those who are learning about EB-5 for the first time, and just give some basic information. EB-5 is a job creation program. You have to show that your investment into a U.S. company is creating jobs for U.S. workers. And when you go invest through a regional center, you're able to count indirect and induced jobs that are created through construction expenditures. And regional centers will work with economists to prepare an economic report showing how many jobs are going to be created based on future expenditures and future operational revenue. A lot of folks have been asking me recently, what's better, direct EB-5 or regional center EB-5? And there's pluses and minuses for each. It's really an investor decision. From an immigration point of view, I think I've actually seen more success with regional center cases. Direct EB-5 requires W-2 employees on payroll working 35 hours a week. It is difficult to run a new business, and it is difficult to find people to fill the job positions that are there. And you can come into trouble running that business, and that could impact your immigration eligibility potentially. Whereas if you go with a regional center project and you choose it correctly, you can really mitigate that immigration risk by choosing a project where the jobs have already been created or in the process of being created. You can save yourself a lot of headaches, a lot of stress by being a more passive investor in a regional center project. Of course, there are entrepreneurs out there who really want to do their own company. Some companies work, some companies don't. Again, it's the type of jobs that are created and making sure that you have a business plan that is credible, showing how that investment amount, whether it's $800,000 or $1,050,000, is going to be used for job creation purposes. Another question that I get very often is, well, if it's direct EB-5, does that mean I have to do $1,050,000 investment? And the answer is no. The minimum investment level is based solely on where the project or the company is creating the jobs. It is not based on whether you're doing direct EB-5 or doing regional center EB-5. Most of the regional center projects are in rural or high unemployment areas, or because they are able to attract investors at that lower investment level. Who wants to pay an extra $250,000 to get the same immigration benefit? And so that's why they are locating projects in rural areas or in high unemployment areas. And the last big part that I want to talk about are your lawful source of funds. This is something that I'm getting a lot of questions about, in particular for folks in the United States. And there's just a couple comments that I want to make that are generally applicable. Number one, there is no restriction on where the money can come from. It can come from within the United States, or it can come from out of the United States. Just if you're here working on an H-1B and you have W-2 income and you've used that to make investments and you want to now sell those investments or use them to get as collateral to get a loan, you can do that for EB-5. It doesn't have to come from outside of the United States. Additionally, there can be multiple sources of your funds. It does not need to come from just one source. It is very common for folks to have 2-3 sources. You know, they have their W-2 income that they've saved. Maybe they purchased a home a few years ago, and now they're using the equity in the home to get a home equity line of credit. And then they're also getting money gifted from mom and dad back in India. Those are 3 sources. All 3 of them can be used for the minimum $800,000 investment. The RIA also requires investors to show the lawful source of funds for the administrative or subscription fee, the regional center fee, as well on top of the $800K. Okay. Oh, one other item that I forgot to mention about the fees is that in the RIA, USCIS is supposed to do a fee study for EB-5 in order to be able to process cases in a faster manner. The fees that were reflected in this recent notice do not account for that fee study. I don't think that fee study has been done. But my thought would be is if and when they do it, you're going to even see even higher fees, I would think. And so, you know, again, now is the time to file, not only to get your spot in the line, not only to save your hard-earned money on the filing fees, and also for age out protection for your children. All right, so let's keep moving forward. We talked about this generally, but Charlie, can you just maybe just give us a high-level breakdown of how the annual limit for EB-5 visas are allocated?
Sure. This year's annual limit, worldwide employment limit, is 161,000. Then EB-5 would be eligible for 7.1% of that. And then that limit would be further distributed among the 3 categories. So unreserved categories would get 68% of the overall employment limit. The rural category would get 20% of the numbers, high unemployment 20% or 10%, and infrastructure would be getting 2%. So this is a unique thing that the regional or RIA of 2022 imposed. So it's a very beneficial thing for the 3 reserved categories, and the benefit, even better for the 3 unreserved categories, is any numbers that are unused for fiscal 2024 will carry over and be added to the 2025 annual limits. So that is a very beneficial thing. It is unique to the unreserved categories. You don't see that happening in employment first, second, or third.
And that was something that Congress specifically put in the EB-5 Reform and Integrity Act of 2022.
Yes.
Okay. There's not a normal EB-5 investor. It really comes from a huge variety of individuals. Parents do it a lot of times for their children. They can gift the money to their children and have the children be the principal applicant, so that when they graduate from college, they don't have to worry about being in the H-1B lottery or finding an employer. You can file the EB-5 now, file the adjustment of status now, get the EAD in as quick as 3 to 4 months because you have that adjustment of status pending. And now the child has unrestricted work access when they graduate in the summer. That's a huge thing that a lot of people are doing. We mentioned this previously, Chinese and Indian nationals who are backlogged and aren't going to be seeing a lot of forward movement on the final action date in order for their priority date to become current. They are looking at EB-5 as well because of this opportunity to file the adjustment of status today. And those folks can be on H-1B, they can be on L-1. Maybe they've, there's also folks who've created their own business through the E-2 investor visa. Maybe they've gotten a renewal. They don't see a path forward using their E-2 business, but they've saved money from the profit of that company. That can be invested into an EB-5 project and used to get the green card. There are ways that you can enter the United States with the intent to adjust. That's if you come in on an H-1B or an L-1 visa, because those are dual intent non-immigrant visas. But for everybody else, you can't really come into the United States with an intent to adjust. And so this is something that is very, very tricky, and you should really be speaking with a qualified immigration attorney on this issue. And it's very case specific, but you got to be careful on that. But it is something that I get asked a lot of questions about all the time. So I just wanted to raise it here. And this gets to the point that I was mentioning before, where when you file your EB-5 case, if it's in a reserve visa category, because it's current, you can file your adjustment of status. And with the adjustment of status, you get the interim benefits of the employment authorization document and the advanced parole. Those are coming in as quick as 3 to 4 months. They're issuing combo cards. So it's a work authorization card, which also serves as advanced parole. And those are good for 5 years. And you can continue to use that EAD even if the Department of State puts a final action date for your reserve visa category and your adjustment hasn't been approved yet. Your adjustment would remain pending, and you could continue using those interim benefits in the meantime. And it's 5 years, so it's probably won't even have to renew it as well. And as well, there's this INA 245K protection, and it allows folks who potentially are out of status or working without permission to still be eligible to file an adjustment of status, despite those non-immigration violations. And this is particularly important for folks on H-1B who are laid off, and maybe they haven't been able to find an employer to transfer to during the 60-day grace period. Well, just because they're out of status at that point doesn't mean necessarily that they can't file the adjustment of status because of this INA 245K protection. Again, this is a new thing that is in the EB-5 Reform and Integrity Act and provides some benefits to prospective EB-5 investors. So this is the chart. We have talked about this, I think, in a couple of our prior Chatting with Charlie EB-5 investor outlooks. And if you want to go on YouTube and look at it at your leisure, go right ahead. But this, I'm looking at the line that says fiscal year 2024, and here you see that there's just about 6,000 more unreserved visa numbers this year than reserve visa numbers. And Charlie, I believe this kind of gets to your point that we had from the beginning of we got to make sure that these numbers are used, because if they're not, then they could be lost to EB-5 forever, right?
Yes, this would take a significant reduction in the EB-5 unreserved waiting list, and it will be a tremendous shame if these numbers are not fully utilized this fiscal year. And unfortunately, looking at the data that the State Department has already published in terms of number use for October and November, it does appear that very minimal amounts of these numbers are being used. So for whatever reason, so far, it looks like a tremendous amount of unreserved numbers will be wasted unless there is a big change in number use. going forward.
So let's talk about that number use just for a moment. I mean, Charlie, normally by this point, we would have the Department of State's annual report for total visa use for fiscal year 2023, right?
Yes.
That hasn't been published yet.
No, we're 4 months into the fiscal year, and no data has been published in terms of the tables under the 2023 report of the Visa Office. I need to say that when I was chief, the information was also delayed, but we would normally have posted the table 5 data, which shows worldwide number use in the family and employment categories no later than the middle of December. So that is the one of the most important from immigrant visa statistics, and that's why we would get it published first. We would also publish the National Visa Center waiting list as of November 1st of that fiscal year, and we would publish that report by the middle of December as well. So nothing for the fiscal 2023 report of the Visa Office has been published, and the NVC waiting list as of November 1st, 2023 has not been published. And that would be very interesting information to see, because it reflects the data on what is pending and needs to be addressed overseas.
Interesting. So do you have any idea when we may expect those to be issued? I guess you would have thought they'd be issued by now already.
I would have thought, and I think I was asked in one of our other, the Visa Bulletin calls, when I expected the information to be posted. And I said, I think long ago, that I thought by the middle of December, I expected table 5 of the annual report to be published and the NVC waiting list. Neither have been done. It's extremely surprising to me that neither of those reports have been published and nothing else. So all that information is extremely important to those who are interested in the immigrant visa information, and also those that are interested in the topic of non-immigrant visas. So that annual report information is key to a lot of people that are interested in the industries.
I want to focus everyone to the reserve total column. And you can see that in fiscal year 2024, when you include the carryover from the previous year, there's about 8,000 of these reserved visa numbers. And Charlie, can you just kind of confirm why that number is so important for the Visa Bulletin indicating C right now?
Yes, because any of the unreserved numbers, the reserved numbers from the current fiscal year, as I mentioned, carry over to the next fiscal year, and the reserve numbers from the second preceding fiscal year carry over to the unreserved category. So it's kind of a difficult thing to follow through, but both the carryover, these numbers are very beneficial to both unreserved applicants and reserved applicants. And it is very important that the maximum amount of numbers be utilized so that the numbers are not wasted, because every number that is issued this year and used reduces the amount of applicants in line waiting for a number next fiscal year. So, we haven't had any numbers used despite the fact that the law came into effect in March of 2022. We're only, as you mentioned, seeing the first number used almost 2 years later.
Right. And the supply
and again, all the numbers, all the fiscal 2022 numbers that fell across and are available for unreserved, those are just thousands of numbers that are not available to reserved applicants. So,
right. And the supply of reserve visas is so big that until USCIS processes more of these I-526Es, we're not going to see a final action date, because the supply exceeds the demand.
Right. The number, we're not going to have enough numbers being used. So, for example, if the limit is 7,773, State Department would not impose a final action date until number use was going to exceed that number. And so, again, that's not going to happen in fiscal 2024, which will allow everything to stay current. And the reserved categories, I believe, will stay current well into fiscal 2025, unless there is a tremendous uptick in number use by overseas posts and the Immigration Service, which there's no evidence of that happening at this point.
Thank you. Well, that's pretty much the end of our current webinar here. I do see a great question that I want to ask, and I want to open it up. If people do have questions, please feel free to do it. But Charlie, this question, I don't know if you can speak too much to it, because I know it's not really related to visa use, but someone is asking about the Child Status Protection Act and the difference between USCIS and Department of State policy with regards of using Chart B to calculate the green card, the applicant's age. And USCIS has said that they will use Chart B, whereas the Department of State has said, no, we're only going to use Chart A. That's an interpretation of the Child Status Protection Act, right? And
correct.
Different departments can have different interpretations.
Yes, and this was a topic that was being looked at by the Department of State attorneys while I was working. Evidently, they still haven't resolved the issue to change their policy. Many have said that it would be nice to have a single policy and for the State Department to adopt the policy imposed by the USCIS. But again, having two separate policies in effect is very confusing for those in the industry and the applicants trying to monitor the situation.
Right, and it's quite frustrating when someone who's in the United States may be able to take advantage of it, but just because you're outside, you're getting treated differently. I do know that the American Immigration Lawyer Association has been raising this issue with the Department of State. They have been advocating for them to change their position. It's just hasn't happened yet, but I am very hopeful that we can get some change, maybe. If we hear about anything, we would obviously be discussing it on our next webinar. All right, question here. Ed Bashara from Florida is asking, can one EB-5 investor only be in a regional center project? The way that the RIA is written is that if you are pooling investments or intending to pool investments from more than one EB-5 investor, it should be a regional center project. You no longer are allowed to do direct pooled EB-5. So if you're doing direct EB-5, it can only be the investment funds of one EB-5 investor. Well, this is a great question. Why is it taking 90 days to receive the I-526E filing receipts, where other filings happen within a couple of weeks? This is another issue that we have raised as the AILA to IPO. It doesn't make any sense why it takes them so long. Generally, when you file an I-526E, you file it with the lockbox in Texas, and then you get a receipt saying, hey, we received your fee. Then the case is either transferred or scanned to IPO, which actually adjudicates the EB-5 cases, and they issue the official I-526E receipt notice. That is the part that has been delayed. We have clients who filed in November of 2023 who still have not received their I-526E official receipt notice. It is a systematic issue. It's not your attorney's fault. It's not your fault. It is a USCIS issue that I think they're trying to fix. On the same lines, it's once these I-526Es are approved, they're supposed to transfer them to NVC so that they can schedule consular interviews and use those visa numbers. That is also being delayed by IPO. We have been inquiring about that as well. And we unfortunately haven't gotten too much too much meaningful feedback on this. All right, I have another question. I think USCIS does not allow pooled investments in RC programs. No, if it's a regional center case, it must be a pooled investment. That's what they're saying. Before, you could do pooled direct. Now they're saying, no, only one EB-5 investor can do direct. Are regional centers seeing long delays in I-956F filing receipts or just us? I don't know how long the delay is that is being referenced here, but yes, it can take numerous weeks for IPO to issue those. Again, it's the same process where you get the filing fee receipt from the lockbox for the I-956F and the I-956Hs that go along with it. And then it can take a little bit of time to actually get the official approval notice, or excuse me, receipt notice. Okay, well, this was 45 minutes. You probably heard me talk enough. Charlie, thank you so much for your expertise and your insight. It is always greatly valuable, and we are so thankful to have you on. For everybody who's listening on YouTube, feel free to reach out to us if you have any questions about your EB-5 case. My email is right here, jbarnett@wolfsdorf.com. I'm happy to answer any questions and to help you get your green card through EB-5. So thank you very much. Hope you have a great afternoon and look forward to assisting you in the future. Take care.